Hi, I'm Professor Laser, and let's get ready to learn innovation law. What is the doctrine of patent misuse? And when should we use fairness as a basis to decline to enforce intellectual property rights? During the COVID-19 pandemic, some called to eliminate or waive intellectual property, such as patents, copyrights, and trade secret protections, on technologies that help to prevent, contain, or treat COVID-19. Previously, some called for the elimination of intellectual property rights on EpiPen technology, a critical treatment for anaphylaxis for allergic reactions. And in 2018, a federal court wiped out a $200 million jury verdict of patent infringement because of the judge's determination that the patentee acted with unclean hands in equitable defense in its business transactions and behavior before the court. Several equitable defenses are available in U.S. patent law to defend against a case of patent infringement. The equitable defense that we'll talk about today is called patent misuse. Section 282 of the Patent Act makes available certain defenses in any action involving the validity or infringement of a patent. Among defenses such as non-infringement, Section 282 provides that unenforceability of a patent is a defense, but it's not defined. And in this circumstance, we use statutory interpretive canons to direct judges to define the scope of unenforceability as it was used in established case law at the time of enactment. Now, this hasn't always been the way that we interpret statutes, but it's the most common method now used by the current Supreme Court. Patent misuse is an unenforceability defense that's related to the doctrine of unclean hands. They're both equitable defenses. And patent misuse has historically been used to prevent a patentee from exploiting a patent right beyond the scope of the patented invention. For example, by extending the reach of the claims, or beyond the duration, by extending it past 20 years, for example. In a 1942 case finding patent misuse, this was one of the first. A patentee of a machine for depositing salt tablets into cans leased its machines to customers on the condition that its lessees purchased unpatented salt tablets from the patentee. After a competitor began to sell an allegedly infringing machine, the patentee brought suit against the competitor for direct patent infringement. The Supreme Court found that the patentee's conduct in tying the lease of a patented machine to the sale of salt tablets was contrary to public policy. The court noted, the courts, especially in equity, may deny relief where the plaintiff is using the right contrary to the public interest. What's a court of equity, though? U.S. courts used to be divided between courts of law, which decided damages, and courts of equity, which had the power to force someone to do or stop doing something. Courts of equity traditionally had more freedom to consider questions like fairness, whereas courts of law would simply apply the law as it was written. The courts of law and equity eventually merged, allowing U.S. courts the power to both order money damages and issue injunctions to force or stop conduct. As the Salt case showed, this was a case of equitable relief following an injunction. So this was a situation where the court determined that equity would not support the court's aid in stopping patent infringement with an injunction until the conduct ceased. The Supreme Court found the same thing, patent misuse, in a few other types of cases, but all of them were brought in equity, and all of them involved some sort of anti-competitive conduct extending the scope of the patent right, such as tying it to the sale of an unpatented item. Although anti-competitive conduct can constitute patent misuse if it extends the patent right, the current reach of the misuse doctrine is not exactly coextensive with antitrust laws. Since the 1950s, the Supreme Court has not found any conduct to be patent misuse, but that hasn't stopped litigants from repeatedly raising the issue in lower court. As my late mentor, Professor Burke, noted, in recent years, misuse is invoked as a low-cost substitute for an antitrust analysis, and as a bargain basement, all-purpose claim against patent enforcement. I was on cases, for example, where the other side claimed that filing too many patents constituted patent misuse, even if all of those patents were lawfully obtained. I think they were primarily concerned with the use of getting many patents on the same technology in such a way that it extended the protection for a particular drug in particular use cases, but this is lawful. Others have asserted that high drug pricing or using patented technology in ways that contravene public morals could be misuse. But the Supreme Court is unlikely to extend the reach of patent misuse so far beyond its historical roots. Another question is whether patent misuse and other equitable doctrines can wipe out an infringement verdict for money damages. Historically, in the mid-1900s, the equitable doctrines of misuse and unclean hands and others were not used to eliminate damages awards and instead could only limit equitable remedies, such as injunctive relief, other than in very limited situations of fraud or obtaining the patent or judgment. I think that's how the Supreme Court is likely to apply the doctrines of patent misuse and unclean hands if the issues reach the court today, with the current Supreme Court that is more inclined to follow historical roots and this doctrine of looking at the original meaning of the statutory terms. Here, that would be unenforceability. Another question is whether it's reasonable for judges to make the decision of when a patent should be unenforceable as a matter of public policy or a violation of morals. Good cases can sometimes make bad law, and exceptional events or things that seem really unfair can spur judges to take policy matters into their own hands. This is dangerous. When a judge makes a decision that a patent is unenforceable as unclean hands or patent misuse, that can change the market's expectations of the scope and reach of intellectual property rights. And this happens because of a single exceptional event. Judges shouldn't use fairness to justify the elimination of damages for infringement of a valid intellectual property right unless there is some historical basis to do so, like anti-competitive conduct that extends the reach of the patent. The uncertainty that can arise when a judge tosses out patent verdicts on equitable grounds can make it harder to secure financing for innovation and harder to justify investment and development and commercialization of new patented products. Considerations of fairness in particular can lead to greater unfairness when all circumstances are considered, or when we look at cases beyond the one at hand. If policymakers, like legislators, think that a particular issue of unfairness, like high drug prices, should be considered when deciding the enforcement of intellectual property rights, legislators can propose a change to law that goes through the normal process of bicameralism and presentment, meaning it goes to both houses and the president. Legislative bodies, after all, are more equipped to evaluate choices of policy matters than judges. They have more tools available to them, like hearing from constituents and stakeholders and calling for research on potential implications. And decisions by judges, equitable decisions that render a patent unenforceable, should be limited to the historical roots of those doctrines. And that's not to say that misuse could not be found in a novel factual scenario. It could. But that factual scenario should be analogous to those found to be patent misuse in the past, such as the use of anti-competitive or fraudulent means of extending the term of a patent. And they should also be limited to the types of remedies that were available in the past. So specifically, this is considered an equitable defense that can stop an injunction from going into place, but should not be used to destroy a damages award. Thanks for listening. This is Learn Innovation Law with Professor Krista Laser.